अरे
नमस्ते जय जी।
Namaste. We are live on YouTube. Yeah. Sorry. Namaste, Vallabhaji. We are live on YouTube. So I'm going to go on mute for a while.
Sounds good. Sounds good.
Namaskar. Great to see you.
नमस्ते। नमस्ते।
Namaste, everyone. Thank you for joining. Please, I would appreciate if you could state your location in the chat room, just so we know where you're joining from. Dhanyavad.
Sir, we will start whenever you will say.
Yes, just in just about a minute, Vishnuji, we
No.
will start.
Yes, yes.
Huh, huh. Okay, so it's noon hour here on the East Coast in the United States. Namaste, Sat Sri Akal, and Jai Shri Ram. A very warm welcome to everyone who is joined this webinar. This is the third webinar in this series to talk about the 500-year history of 500 history of Hindu struggle to rebuild Ram Mandir in Ayodhya. So this is the third webinar, and I will take a minute or two. I will certainly introduce our eminent speaker and other people on the screen today. But let me take a minute or two to just set the scene for this webinar. Before I do that, just a couple of housekeeping items. Please use the chat room to let us know where you're joining from, your city, your state, your country. Last two webinars, we had people joining from 5 different continents. So you have quite a challenge to beat that. Secondly, we have a Q&A box on your screen. So please use that to ask any questions that you might have. We will not be taking any questions from the chat room. Thirdly, the video recording of this webinar and all the previous webinars will be available on our website, hindudvesha.org, under the video section. So sometimes it takes a day or two for the video to become available. So please be patient, but rest assured it will be available there very shortly. So with that, let me go to the background of this webinar series. As you know, the inauguration of Shri Ram Lala Mandir in Ayodhya is scheduled to be inaugurated on January 22nd, just a few days away from today. It is certainly a momentous occasion that marks the culmination of a 500-year struggle for the construction of a mandir dedicated to Shri Ram at his birthplace. The historical and cultural significance of this event extends far beyond the reconstruction of the mandir itself. Indeed, it symbolizes a spiritual and emotional connection for millions of Hindus around the world to their civilizational roots. As the temple opens its doors on January 22nd, it will become not only a place of worship, but also a beacon of hope for a civilization that takes pride in its rich and diverse heritage. Now, obviously, it's a moment of great joy and pride for all people of Dharma all over the world. But then we must also look back and see how we got here. Can you believe that it has taken us 497 years after the destruction of the original Mandir to get to this point? 497 years, 20 generations. And more than 70 of those years were during the post-independent era where we are supposed to be the masters of our own destiny. Now, let's not forget that the final permission to rebuild the Mandir was the result of a long, drawn-out legal process where a community with 80% of country's population, the Hindu population, was dragged through a long and dirty court fight where every aspect of their belief system was questioned. Now, it is the purpose of this webinar series to reprise this painful 500-year history with a special emphasis on the last 70 plus years. And who can do that better than our eminent speaker, Shri Vishnu Shankar Jayanji. Let me, before I invite him to talk about the legal battle and give him the floor, let me just say a few words about his background. So Vishnu Jayanji is a renowned Indian lawyer who is currently involved in a case related to the Gyanwapi mosque dispute. He is the son of senior Supreme Court advocate Harishankar Jainji, who represented the Hindu Mahasabha in the Ram Janmabhoomi Babri Masjid case. Vishnuji has been a litigator or attorney for at least 12 cases involving Hindu Jain deities. Along with his illustrious father, he's fighting on behalf of Hindus in 110 such disputed cases, including Mathura Krishna Janmabhoomi, the Qutub Minar complex dispute, and the claim of Taj Mahal as a Shiv temple, among many others. Vishnuji is also a spokesperson for the Hindu Justice Front. Please join me in giving a real warm welcome to Vishnu Shankar Jayanji. Namaskar, Vishnuji. बहुत धन्यवाद for taking the time, particularly at this late hour, to join us and share your thoughts. Before I give the floor to Vishnuji to talk about the legal case, may I also, I'd like to introduce my co-host, Vallabha Tantriji. She will be handling the question answer period after Vishnu ji is finished with his talk. And my second avatar is actually not me. It is actually Chandra Bhushanji joining us from Delhi. He looks after our media support. So Dhanyavad Chandraji for being there, and I'm sure everything will go smoothly thanks to all your efforts. So with that, Vishnuji, you know the topic, you know why we're here. So the floor is yours. Please take it over and tell us all about the Ram Janmabhoomi legal case.
A very, very good afternoon to all of you. And I would like to say that धर्म संस्थापना के देवता भगवान श्री कृष्ण के चरणों में मेरा नमन, आप सबको मेरा प्रणाम. And it's truly a pleasure and honor to be a part of this webinar and to share my thoughts on this very, very important and crucial aspect. It was very fortunate for me, and it's a great privilege in any attorney's life and his legal career that he can be a part of such a historical battle. Because if we actually calculate this so-called our temple, I believe that our temple was never demolished, because the settled legal principle is once a temple, always a temple. But to understand the history, in 1528, Babur demolished a pre-existing Hindu temple. And if you calculate from past 500 years, each generation, if you will see, in every 100 years, there are 2 generations. So around 20 generations have passed by, and 20 generations have not seen a Bhavya temple. So we are very fortunate that we are going to be the 21st generation, which is going to see a Bhavya temple, which will be inaugurated on 22nd of January, and Pran Pratishtha will be done. And it will not be just Pran Pratishtha of temple. It will be Pran Pratishtha of emotions of crores of Hindus who were fighting from time immemorial to see this day. I was born in an era when I had seen Ram Lala being worshipped in the outer courtyard of the so-called Babri Mosque. I had seen that era when Ram Lala was worshipped in tent in a makeshift temple. I am now going to see that era, and we all are very fortunate when we are going to see Ram Lala being established on 22nd of January. So it's a civilizational battle, and the beauty of this battle is that despite various reservations which I have against the judgment of the Supreme Court, but the beauty is that we must appreciate the Indian judiciary, because if you will see the world history, the dispute of Jerusalem is persisting from past 2000 years. 3 communities, 3 major religions who believe in the concept of secularism are fighting for Jerusalem from past 2000 years, and no court in the country No big nation in the country, no big organization in the country is able to solve the dispute of Jerusalem. It is the power of Indian judiciary which is able to solve the dispute of Ram Temple in 69 years. So it's a big victory and it's a big message to the entire world community that if these kind of civilizational disputes arise, it can be solved by constitutional mechanisms and it can be solved by established institutions like judiciary. You go to the court, you give your proofs, you give your facts, and the Indian judiciary is competent to handle such kind of cases. Now, to begin with the dispute of Ram Mandir case, when this case was initially filed, the beginning of this case is not just by filing of the case of Gopal Singh Visharat in 1950. Let me tell you, the first case was filed for Puja Archana of Bhagwan Ram Lala in 1950 by Gopal Singh Visharat. But there is a lot of history to it. And if we go into the historical background, everything starts from 1528. In 1528, Babur, who had lot of hatred against pagans, against Murti Pujaks, against idol worshippers, he had taken a vow that just like today I am breaking my wine glasses, in the same way I am going to break the idols of idol worshippers. And this is not what I am saying. It is written in his own autobiography, Babur Nama, and which has been translated by Beverages. It is authentic version which is relied in the Allahabad High Court as well as in the Supreme Court. So it was, many people used to think that Babur was very nice, he was very secular, and he had respect for all religions. No, sir. Please read Babur Nama. And he had taken a pledge that I am going to destroy all the idols, just like I am destroying my wine bottles and wine glasses. In the same way, I am going to break all the idols. And with that pledge, he had traveled to India, to this country, to conquer this country. And apart from that, Babur Nama also mentions that he has massacred Hindus to such an extent कि उनके सर के काट के पिलर बना दिए थे. Pillar heads were, they, so much massacre was conducted by him that he had made a pillar of the heads of Hindus. So actually, in 1528, a temple was demolished, and then the entire dispute starts. And let me tell you, this is very, very clinching and very unique part of this entire case, that from 1528 till 1855, there is no proof of any namaz being offered by any Muslim party in the Ayodhya issue or in the Ramlala temple complex. No evidence. From 1528 till 1855, there is no evidence of any namaz being offered. There is complete silence on part of UP Sunni Central Waqf Board. And on the other hand, from 1528 till 1855, we have documents after documents to show and establish that we were worshipping in the premises in question. There are various travel accounts of Tryfentheller, of Buchanan, of Martin, and various French and Italian travelers have said that Hindus are worshipping there in the premises in question, and they are worshipping Lord Ram, and they are performing their daily rituals. One very clinching aspect of this entire legal journey and historical evidence is the Ain-e-Akbari, which was written in Akbar's time by Akbar's own court master Abul Fazl, and this document is of 1592. In Ain-e-Akbari, Abul Fazl has noted and established that Hindus are worshipping the premises in question, and at Ram Navami there is a huge mela and festival and parikrama which is conducted in 1592. And one very important aspect I want to tell right now, in 1500, and in this case we had also cited the Sikh history. Guru Nanak Dev had worshipped at the Ram temple in 1510, and he had taken bath in Saryu river and he had worshipped at the Ram temple. This fact is mentioned in Guru Sakhi. This was also pointed as before the Honorable Supreme Court while narrating the issue. And apart from that, Iskan Puran and various belief, faith, and astha we have for establishing that Lord Ram was born in this palace, and from time immemorial Hindus are worshipping in the premises in question. And apart from that, various historical aspects from 1528 till 1855 were pointed out before the Honorable Court. In 1855, the dispute arises between the two communities. And the dispute arises when the British government installs a railing there and divides that area into two parts and allows the Hindus to worship in the outer courtyard and the Muslims to offer namaz in the inner courtyard. It is the beginning of the dispute in Ram Mandir case. And it is at that point of time Mahant Raghubar Das had filed a case before the civil court of Faizabad, which was allowed in favor of Hindus. And in 1885, in appeal, that judgment was overturned. And it was noted in the judgment that it is true that Babar has demolished the temple, but it is too late to remedy this historical wrong. And courts of this country are not empowered to remedy this historical wrong. But be that as it may, that was a pre-constitutional decree. And in 1885, this happened. Then after that, the next date, which is very, very important, is 1950, when Gopal Singh Visharad had filed a civil suit before the Faizabad Civil Court. Before that, I want to also point out that on 22/23 December, Ram Lala was prakat in the premises in question. And at that point of time, a very important role was played by District Magistrate of Faizabad, Mr. K.K. Nayyar, who passed an order in exercise of his powers under the CRPC. And Ram Lala, which was prakat there, the worship and everything started on 22/23 December 1949. And for some period, the namaz completely stopped from 22 December 1949, when Ram Lala was prakat. Gopal Singh Visharad filed a case in 1950 for Puja Archana. UP Sunni Central Waqf Board filed their cases. And then in 1989, suit number 5, which is the title suit, was filed by Ram Lala Virajman through next friend Devki Nandan Agarwal. And ultimately, all these suits were clubbed together and the matter came to the Allahabad High Court. Let me tell you that the cases were filed in 1950, but seeing the importance of this matter, in 1989, the Allahabad High Court, in exercise of its powers under Section 24 of the CPC, transferred all the cases to itself for original trial. Generally in UP, all the cases are tried before the Civil Judge Senior Division. So it was rare of the rarest cases, because from past 39 years, the matter was pending in the lower court of Faizabad. And the masses in general were having lot of belief, faith and astha for this legal battle. So seeing the importance of this legal battle and seeing that both the communities are involved, the Allahabad High Court passed an order under Section 24 of the CPC and transferred the original trial before the Allahabad High Court. And a 3-judge bench was constituted for this entire trial. It is at that point of time that the entire Andolan was at its peak. And if you remember, there was a very historical order. And I want to dwell into in this webinar today. Definitely, I will share my thoughts on the judgment of the Supreme Court as well as the judgment of the Allahabad High Court. But there are 4 or 5 incidents of this entire battle which have played a very, very crucial role, because of which today we are going to see this day of 22nd of January. And the first clinching role, which I believe and I feel, is the judgment passed by Justice K.M. Pandey when he ordered darshan of Ram Lala. And you famously know that aspect as ताला खुलने का जो आदेश दिया गया था, जो भगवान राम के दर्शन करने के लिए ताला खुलने का आदेश दिया था जस्टिस के एम पांडे ने, वो एक सबसे क्लिंचिंग और हिस्टोरिकल एस्पेक्ट है इस केस का. दैट वाज द फर्स्ट टाइम दैट इन द एंटायर कंट्री दिस एंटायर आंदोलन came to its peak, and the Hindus felt that they can get justice from the honorable court. And let me also tell you one very interesting aspect which is been brushed in the history, which is not talked about. Justice K.M. Pandey, who ordered darshan and who ordered opening of locks of Ram temple in 1986, he was the district judge of Faizabad. his promotion was due as the judge of Allahabad High Court. At that point of time, the practice was that for promotion of a particular judge, the file goes to the Honorable Chief Justice of the Allahabad High Court as well as the state government. At that point of time, Mulayam Singh Yadav was the Chief Minister of Uttar Pradesh. And Mulayam Singh Yadav passed an order saying that Justice K.M. Pandey should not be promoted to the High Court judge as an High Court judge. And his secret note, as it is verbatim, I am telling you, he mentioned in his secret note that Justice K.M. Pandey is a very honest and brilliant judge. But since he has ordered for opening of locks of Ram Temple, I cannot recommend his name for promotion as a High Court judge. So the point here which I am making is this, that kindly see that judiciary was working in an independent manner, but there was continuous pressure from political masters and from political parties to do something or not to do something. And the same thing is seen in the case of Justice K.M. Pandey. Justice K.M. Pandey, who ordered for opening of locks, his promotion was rejected by Mulayam Singh Yadav solely on the ground that he made such an order. And it was a very, very important aspect of this entire case. Apart from that, in 1990, we know that there were a lot of car sevaks which were killed in firing by the Mulayam Singh Yadav government. And the irony is, and the draconian part is, that around 400 to 500 car sevaks were killed in this firing by the state government, who were not having any weapons. And the state government had the audacity to come in the court and say, and in the public, that only 16 car sevaks had died. So you did not give appropriate compensation to the people on whom the innocent car sevaks whom were fired brutally and massacred. And the irony is that recently, as recent as 2018, the Honorable ex-Chief Minister Mulayam Singh Yadav accepted that he ordered firing on car sevaks, and it was important to win the confidence of Muslims. FIR was also lodged against him, but no action was taken. And FIR was not even registered. So this was another very important aspect. The third very, very important aspect was that the state government headed by Mr. Mulayam Singh Yadav used his entire power to surround that area by the policemen. And there was a time when all the dharamshalas which was surrounding Ram Temple were filled by the policemen of state government. And it was at that point of time when my senior Mr. Harishankar Jain filed a petition before the Allahabad High Court. The Allahabad High Court sat on by organizing a special court on Diwali, and all the dharamshalas were ordered to be vacated. So I'm telling all these aspects because while coming to the main question, there were a lot of side battles which were fought, which paved the way for the judgment of the Supreme Court and the Allahabad High Court. And the fourth very, very crucial and clinching aspect is the acquisition of that 2.77 acres of land, which was ultimately challenged before the Allahabad High Court. And it is blamed upon the car sevaks that you had taken law in your own hands and you demolished the disputed structure. But the fact of the matter is that please read the judgment of Justice Brijesh Kumar, who has mentioned in his judgment that our judgment was ready, but Justice H.H.A. Raza, Mr. Justice Raza, judgment was not prepared. The judgment of Justice Raza was to be delivered on before 6 December 1992, but he failed to deliver that judgment within the stipulated time. So this aspect must also be seen. And the fifth and very, very crucial aspect, and which I believe and I feel was the turning point in this case, was that after 6 December 1992, when that disputed structure was demolished, on 20th of December 1992, my senior Mr. Harishankar Jain filed the petition before the Allahabad High Court, Lucknow bench, and asked for darshan and puja of the Ram Lala. And on 1st January 1993, Justice Harinath Tilhari directed darshan of Ram Lala. And in the first time in the Indian legal history, it was noted in the judgment of the Allahabad High Court, and it was argued before the Allahabad High Court that Lord Ram is a constitutional entity. The Lord Ram is there in the original text of the Constitution, in the original preamble and various parts of the Constitution. So Lord Ram is recognized by the framers of the Constitution, and no one can stop darshan of Lord Ram. and that found favor with the Honorable Court. And on 1st January 1993, the Darshan of Lord Ram was opened by Justice Harinath Tilahri by order of 1st January 1993. That was very, very clinching, because after that the Ayodhya Acquisition Act was passed and the status quo was maintained. And if that judgment would not have come on 1st January 1993, and if our worship and belief and faith and our rituals were not continuing from 1st January 1993 till 9th November 2019, I believe that we would have seen a different judgment, because in the round of mediation and in the round of settlement, there were various other talks of making a hospital there, of making a college there. So it was that judgment which made our belief, faith, and astha continue after demolition from 1st January 1993 up till 9th November 2019. And now coming to the legal case, when all these cases were clubbed together and brought before the Allahabad High Court for original trial in 1989, the trial happened before the Allahabad High Court. Various evidences were led before the Allahabad High Court. Shri Ram Bhadracharya was the star witness for Hindu parties. And when the question arose that where is the importance of Ram Janmabhoomi mentioned in the Shastra and Puran, Shri Ram Bhadracharya gave all those evidences on all those Shastrik Mahatva of Janmabhoomi before the Allahabad High Court. And ultimately on 30th of September 2010, the three-judge bench of Allahabad High Court passed a split verdict, and despite agreeing with the Hindus in principle on many issues, and despite dismissing the suit of UP Sunni Central Waqf Board and Nirmohi Akhada, the suit property was divided into three parts, and 1/3 was given to Ramlala Virajman, 1/3 was given to Nirmohi Akhada, and 1/3 was given to UP Sunni Central Waqf Board. All the three parties filed their respective appeals before the Supreme Court in 2011. Let me tell you, the judgment was delivered by the Allahabad High Court on 30th of September 2010. The matter traveled to the Supreme Court. And before the Supreme Court, it took 9 years for the matter to get ready. All the documents were translated, because many documents were in different languages, in Persian, in Urdu, in various other languages. So translations were done. The UP government played an important role in preparing all the papers and translations and files of this entire case. And from 2nd of August 2019, the final hearing began before the bench of Justice led by Honorable Mr. Justice Gogoi. And before that also, there were a lot of attempts which were being made by Mr. Kapil Sibal and various other senior lawyers to see to it that this case is not taken to its logical conclusion. If you remember, Mr. Kapil Sibal had made a statement before the Supreme Court that this case must be decided after 2019 general elections. Mr. Rajiv Dhawan used the floor of the Supreme Court to call Hindus as Talibanis. Mr. Rajiv Dhawan used the floor of the Supreme Court to tear the map of Ram Temple before the 5-judge bench of the Supreme Court. And all these acts were done. But it was the patience of the Hindu lawyers and Hindu parties who believed in their historical records, who believed in their Shastrik Mahatva of Ram Temple. And we made our arguments before the Supreme Court in 18 days. 18 days, it was a very collective effort. And the team was led by Honorable Mr. Parasaran, a very, very senior lawyer of the Supreme Court. He is 96 years aged. And it was not just his argument. It was his tapasya, which we all were seeing when he was arguing before the Supreme Court. The team was also having Mr. C.S. Vaidyanathan, Mr. P.S. Narasimha, Mr. Harishankar Jain, Mr. P.N. Mishra. All the lawyers had made their arguments, and apart from that, Bhaktivardhan Singh, Mr. Yogeshwaran, all of them had played a very, very crucial aspect, and it was a very big collective effort to make all these arguments simplified before the Supreme Court. And the arguments were very simple. That the historical records which I am mentioning before you today, that historical record, the Honorable Court can take judicial notice of this historical record by virtue of Section 57 of the Indian Evidence Act. All these historical records, court can take judicial notice. It was a unique case where the Hindu parties were also reading verses of Quran and Hadith to show that what is there in the Islamic law. And this entire premises is not a mosque as per Islamic law. The members of UP Sunni Central Waqf Board were reading various Upanishads and Iskan Puran to counter our arguments. So, to think about this entire case intellectually, it was a very big intellectual exercise where both the communities were reading the documents of each other to prove their point. And ultimately, the point was this, and our case was this, that a pre-existing temple was demolished. And after demolishing a pre-existing temple, it was given a shape of a mosque, and it is not a mosque as per tenets of Islamic law, and it is not a mosque as per established principles of Hindu Shastric law. Because Hindu Shastric law is very, very clear. Once a temple, always a temple. And this has been noted by the Honorable Supreme Court in the judgment which has been delivered on 9th November 2019. And the judgment of the Supreme Court is reported in 2019 1 SCC page 1, where the Supreme Court has dealt with the rights of Hindu deities. And the Supreme Court has said that even if you demolish the temple, the right of the deity does not extinguish. The vow, the sacred vow to establish a temple has a legal entity. जो मंदिर बनाने का संकल्प होता है वो अमर होता है, वो अमिट होता है, और उसको ज्यूरिस्टिक एंटिटी माना है सुप्रीम कोर्ट ने. आप भले ही मंदिर तोड़ दें, मंदिर तोड़ने से देवता का अस्तित्व खत्म नहीं होता है. तो जो सेटल्ड इस्लामिक प्रिंसिपल है, ये तो हम लोगों को बहुत जल्दी समझ में आता है जब बड़े बड़े बैरिस्टर कहते हैं वंस अ मॉस्क ऑलवेज अ मॉस्क, वंस अ वफ ऑलवेज अ वफ. अरे भाई, सेटल्ड हिंदू प्रिंसिपल भी है, वंस अ टेम्पल ऑलवेज अ टेम्पल. और एक बार अगर किसी जगह मंदिर की स्थापना हो जाती है तो समय के अंत तक मंदिर की रहती है, राजा भी उसको नहीं ले सकता. सो दीज वर द प्रिंसिपल्स, शास्त्रिक प्रिंसिपल विच वर आर्ग्यूड बिफोर द सुप्रीम कोर्ट एंड विच फाउंड फेवर बिफोर द सुप्रीम कोर्ट. और जहां पे सुप्रीम कोर्ट ने जजमेंट में पैरा 106 ऑनवर्ड्स देवता के राइट्स बताए हैं, उसको उस पूरे जजमेंट की हेडिंग है ज्यूरिस्टिक पर्सनैलिटी. और उसमें सुप्रीम कोर्ट ने बहुत सारे एग्जाम्पल्स दिए हैं. एक कंपनी का एग्जाम्पल दिया है कि कंपनी के डायरेक्टर्स आते और जाते हैं पर कंपनी रहती है. उसी तरह से शिप, एक शिप को लिविंग एंटिटी माना गया है उससे काम करने के लिए. और उसी तरह से सुप्रीम कोर्ट में यह बताया गया कि हिंदू डेटी इज अ लिविंग एंटिटी, इट इज सब्जेक्ट टू टैक्स. हिंदू डेटी गिव्स टैक्स एंड इट इज टैक्सेबल. हिंदू डेटी हैज अ राइट टू सू एंड इट कैन बी सूड. और डेटी होने के लिए कोई जरूरी नहीं है कि वहां पे कोई मूर्ति हो. मेरे सीनियर माननीय पराशरन साहब ने सुप्रीम कोर्ट में चिदम्बरम मंदिर का उदाहरण दिया तमिलनाडु में, जहां पे कोई मूर्ति नहीं है पर वहां पे भगवान शिव की पूजा होती है पर्दा हटा के हर 5 मिनट में. तो बहुत सारे उदाहरण दिए गए और यह भी बताया गया सुप्रीम कोर्ट में दैट दिस प्लेस इटसेल्फ वेयर लॉर्ड राम इज बॉर्न इज अ स्थान देवता. प्लेस इटसेल्फ इज अ डेटी. So all these arguments were raised before the Supreme Court. And let me also come to the very, very crucial aspect. Many people you would have heard on various television channels who would have said that Supreme Court ने कोई finding नहीं दी है मंदिर तोड़ने की. There is no finding of any demolition of a temple. Sir, please read and correct me if I am wrong. 2019 1 SCC page 1, paragraph 730.7. And let me read it. Paragraph 730.7 for you. The Supreme Court has very categorically held that a temple was and a structure was existing beneath the so-called Babri Mosque, and that structure was a non-Islamic structure. So I am just exactly reading before you and quoting the judgment of the Supreme Court, and I'm reading paragraph 730.7, which has dealt with this issue. Yes. And I quote the paragraph 730.7. Artifacts, including architectural fragments which have been recovered during excavation, have a distinct non-Islamic origin. Though individually some of the artifacts could have been utilized in a structure of Buddhist or Jain origins, there is no evidence of the underlying structure being of an Islamic religious nature. The conclusion which has been drawn by the ASI that the nature of underlying structure and the recoveries which have been made would on stylistic grounds suggest
the existence of temple structure dating back to 12th century AD would, on a balance of probabilities, be a conclusion which is supported by evidence. The conclusion cannot be rejected as unsupported by evidence or lying beyond the test of preponderance of probabilities which must govern a civil trial. So it was, and I unquote the judgment. So this was very, very clear that the structure which was lying this beneath structure was a non-Islamic structure. And in this so-called structure, there was वरा देवता की मूर्ति, हनुमान जी की मूर्ति, 14 कसौटी के खंबे मिले थे, जो एक हिंदू मंदिर के खंबे थे जिसपे ये सो कॉल्ड बाबरी मॉस्क खड़ी हुई है, श्री विष्णु हरि शिलालेख मिला था. सो देयर वाज अबंडेंस ऑफ मटेरियल. एंड लेट मी आल्सो टेल यू, जब 2002 में जस्टिस ऑनरेबल जस्टिस सुधीर नारायण साहब ने वहां पे आर्कियोलॉजिकल सर्वे का ऑर्डर किया था, तो उस समय जो ट्रेंचेस खोदी गई थी एक्सकेवेशन के लिए, तो बहुत बड़ा हल्ला हुआ था कि नहीं, यहाँ पे ट्रेंचेस ना खोदी जाए, यहाँ पे ट्रेंचेस ना खोदी जाए. अभी जब राम मंदिर का निर्माण हो रहा था, तो निर्माण के दौरान बहुत सारी मूर्तियां मिली, हजार कितनी मात्रा में मूर्तियां मिली हैं. उस समय अगर वो ट्रेंचेस खोदी जाती तो उस समय वो मूर्तियां मिलती, पर उस समय बहुत जगह ट्रेंचेस खोदने से मना किया गया फॉर वेरियस रीजंस. कैनेडियन एजेंसीज आई थी जिन्होंने बताया था ये एएसआई सर्वे के ऑर्डर होने से पहले कि यहां पे एक डिस्प्यूटेड स्ट्रक्चर है स्ट्रक्चर के नीचे. एंड व्हाई वी आर ऑलवेज एम्फसाइजिंग ऑन दिस पॉइंट कि स्ट्रक्चर के नीचे एक और स्ट्रक्चर है, to prove the point that Babur did not raise any fresh construction. A pre-existing structure was utilized and it was given a shape of a mosque. Same is the case in Gyanvapi, and same is the case of Mathura, and same is the case of various many more temples in the country. So the point is that the Islamic invaders never made any fresh construction. They partially demolished the temple. जो हिंदू देवी देवताओं की मूर्तियां होती थी उसको नष्ट कर दिया, उसके फेस तोड़ दिए गए, जो हमें कुतुब मीनार में भी दिखता है और जो राम टेम्पल में भी रहा, और उसी प्रीमाइसेस को मॉस्क के रूप में यूज करने लग गए, जो हिंदू शास्त्रिक नियम के भी खिलाफ है और इस्लामिक लॉ के भी खिलाफ है. तो ऑल दीज आर्ग्यूमेंट्स वर रेज्ड बिफोर द सुप्रीम कोर्ट, एंड अल्टीमेटली the Supreme Court passed the judgment on 9th of November 2019. And let me also dwell little bit into this aspect of mediation and compromise. And there is something which is very, very serious here. Before the Honorable Supreme Court, it was the chances were given to the parties to settle the dispute through mediation and through talks. And the Supreme Court also passed an order saying that whatever talks are made in the mediation will not be disclosed by any party before any media house. And in the mediation, which was headed by Mr. Shri Ravi Shankar and Honorable Justice Khalifullah and Shri Ram Panchu, the talks were that you give us, we will give you, हम आपको राम मंदिर दे देंगे, पर इसके बदले हमें ऑल्टरनेट लैंड दीजिए. हम आपको राम मंदिर दे देंगे पर इसके अलावा कोई और इशू रेज ना किया जाए, काशी मथुरा और बाकी मंदिरों पे कोई बात ना हो. And precisely, if you will see the submission of the UP Sunni Central Waqf Board before the Supreme Court, at the end they said कि इस देश के सेक्युलरिज्म को मेंटेन रखने के लिए आप हमारे इंटरेस्ट को भी देखें. So I believe, and I want to strongly say today in this webinar, and I was the only Hindu party who filed a review petition in the Supreme Court against the judgment of the Supreme Court, because I believe ये इंटायर जो फाइट थी, हमने वो दौर देखा है जब हमने ये कसम खाई थी बच्चा बच्चा राम का, जन्मभूमि के काम का, सौगंध राम की खाते हैं, मंदिर वही बनाएंगे. और ये पूरा आंदोलन और रेवोल्यूशन यही था कि हमारे मंदिर को तोड़ के मस्जिद बनाई गई है. एंड the Supreme Court, I am strongly saying and boldly saying on your webinar, the judgment of the Supreme Court is erroneous so far as 5 acres is given to UP Sunni Central Waqf Board. That 5 acres should not have been given. Because आप देखिए द आयरनी, आप पहले मेरे मंदिर में घुस आए, हमारे देवी देवताओं की मूर्तियां तोड़ दें, उस जगह को इलीगली आप उसमें नमाज पढ़े 1855 से आप वहां पे गलत ढंग से नमाज पढ़े, और उसके बाद जो आपने गलत ढंग से नमाज पढ़ी है, instead of you giving compensation to a community, instead of you apologizing to a community, we are giving you 5 acres of alternate land. And today they are taking a vow कि जब भी उनकी सल्तनत आएगी दोबारा राम मंदिर तोड़ देंगे. They are making all the arrangements to build a huge mosque which can be seen from kilometers and kilometers. So the point is that the entire fight was कि यहाँ पे बाबर ने गलत ढंग से हमारे मंदिर को तोड़ा है, और उसके लिeu में, in lieu of this land, no land should have been given to UP Sunni Central Waqf Board. And the Supreme Court exercised the powers under Article 142 to give 5 acres of alternate land erroneously. और वो आगे चल के दिखेगा सर, जब वहां पे एक बहुत बड़ी मस्जिद तामील की जाएगी, वहां से दोबारा कस्में खाई जाएंगी इस मंदिर को तोड़ने की. सो आई एम जस्ट सेइंग विद लॉट ऑफ सेंस ऑफ रिस्पॉन्सिबिलिटी कि हम तो 22 जनवरी देख रहे हैं, पर हमें अपनी जनरेशंस को तैयार करना है कि आगे हमारा मंदिर प्रोटेक्टेड रहे और दोबारा कोई बाबर या औरंगजेब ना पैदा हो उस मंदिर को तोड़ने के लिए. क्योंकि बहुत सारे ऐसे लोग हैं जो अभी भी कसम खा रहे हैं कि जब हमारा दौर आएगा तो इस मंदिर को तोड़ देंगे. हमने बहुत बड़ा मंदिर बनाया है, ऐसा मंदिर बनाया जिसको 1000 साल तक जिसकी नींव रहेगी, पर हमें ऐसे लोग भी खड़े करने हैं जो 1000 साल और हजारों साल तक इस मंदिर की रक्षा कर सके. और भगवान राम की जो विचारधारा है, जो उनका चरित्र है, जस्टिस टू ऑल अपीजमेंट टू नन, जो राम राज्य की परिकल्पना है, उसको स्थापित किया जा सके. So these are the aspects, and coming back to the judgment of the Supreme Court, I believe that lot of legal principles were decided by the Supreme Court and many legal principles were left unturned. मीडिएशन के दौरान बहुत सारी कोशिश की गई कि कैसे भी करके इस मामले को सेटल किया जा सके, और मैं ऐसा मानता हूं कि जहां पे 2 कम्युनिटीज इन्वॉल्व हैं, 10-20 लोग एक टेबल पे बैठ के मीडिएशन नहीं कर सकते. और देवता की संपत्ति के साथ, भगवान की संपत्ति के साथ कभी कोई कॉम्प्रोमाइज नहीं हो सकता है. When the matter was referred for mediation by the Supreme Court, my senior Mr. Harishankar Jain said that this matter cannot be solved through mediation because Order 23 Rule 3 में ये प्रोविजन है कि जो रिप्रेजेंटेटिव सूट होता है उसमें कोई कॉम्प्रोमाइज नहीं हो सकता है. और काशी के केस में इसलिए हमने ये स्टैंड लिया है कि हम कोई मीडिएशन की टेबल पे या सेटलमेंट की टेबल पे नहीं बैठेंगे. 5, 10, 20 लोग मिलके देवता की संपत्ति के साथ कॉम्प्रोमाइज नहीं कर सकते हैं, और देवता की संपत्ति के साथ कॉम्प्रोमाइज करने का किसी को हक नहीं. तो ये 42 डेज की जो हियरिंग रही सुप्रीम कोर्ट में, इस 42 डेज की हियरिंग ने taught us a lot. We had seen the vigor, we had seen the commitment of my senior Mr. Parasaran, who had argued before the Supreme Court barefoot, and we had seen this entire legal arguments made by various sides, and ultimately the Supreme Court on 9th November 2019 gave an historical judgment, and now we are going to witness the Pran Pratishtha ceremony on 22nd of January. But I am saying that this was a civilizational battle, and many things are still left to be fought and won. Yes, sir.
Vishnu, what a powerful presentation. I mean, you have lived through this, your illustrious father has lived through this, and this is coming straight from the heart. I think I can say without reservation that the entire Hindu community is proud and indebted to Dharma warriors like yourself. Thank you very, very much. Now, there are a number of questions in the QA box that my co-host Vallabhaji has been looking at and curating. So I will invite her to pick up some of the questions, relevant questions to this talk. And I also have a bunch of questions, but I think first let's give the floor to the audience through Vallabhaji. Please unmute yourself, Vallabhaji, and please go ahead.
Everyone. Can you hear me okay, everyone?
Perfect. Yeah.
Perfect. Okay. That was a very thought-provoking presentation, Vishnu, Shankarji. Everybody in the chat have been, telling that. And, we have audience from Italy, Nigeria, not to mention the 50 states of United States of America watching you. And it's a global event webinar going on. And thank you for sharing your thoughts on this. And I will start with some of the questions. The first one is, many congratulations to you on this path-breaking accomplishment. Kindly inform if the original or its copy of the title is still in existence. I'm thinking the question person here wants to know if the title of the land, Ram Janmabhoomi, is still available or is in existence. Can you throw some light on this, sir?
It was a title dispute between the two communities, and it was a title suit which was filed in 1989 by Devki Nandan Agarwal, who was the next friend of Ramlala Virajman, and the suit number was number 5. And ultimately, the Supreme Court has decreed suit number 5, and this entire area has been given to suit number 5, Ramlala Virajman, through next friend Devki Nandan Agarwal, who was dead, and at his place, Loki Pandey was substituted. So the title is now at present with Ramlala Virajman.
Okay, wonderful.
It
Thank
is
you. Thank you.
maintained by a trust which has been created by Act of Parliament.
Perfect.
Shri
Thank you.
Shri Ram Janmabhoomi Tirth Kshetra Trust.
Thank you. Thank you for that answer. The second question is, as you know, the Waqf board can be killer for Sanatana Dharma. What are we doing to abolish it? Do we have enough support from our community in the fight?
See, Waqf board has been challenged by us before various high courts of this country. And I had done a lot of research on various aspects of Waqf Act 1995. And I believe that and I've given a detailed presentation, and I'll share it with the host, detailed presentation, PowerPoint presentation on each and every section of the Waqf Act 1995, that how it is draconian, how it is discriminatory, and how it gives power to the Waqf board. And because of this power, today after defense and railway, the Waqf is the third highest landowner in the country. And we have challenged the constitutional validity of Waqf Act 1995 before the Delhi High Court, before the Allahabad High Court, before Chandigarh High Court. And there are around 200 petitions which are pending in different high courts challenging the same provision. What I have done is that the petition which I prepared, I shared it with various colleagues who were there in various other states. And they challenged the same, on the same lines, the provision was challenged before various other high courts. So today it has become a revolution against Waqf Act 1995, and the soon matter will travel before the Supreme Court, so that the Supreme Court can give a quietus to this entire dispute. So we all are aware about the draconian powers of Waqf Act 1995. The central government is also aware about the various provisions of Waqf Act 1995. And I think very soon it will be abolished either by the parliament or by the court. Until that time, we are fighting each and every day against the illegal encroachment which is made by Waqf board and the Waqf Act 1995. Let me tell you, recently I received a call where a Muslim member is परेशान है, उनकी जमीन को वक्फ संपत्ति घोषित कर दिया, and he is running from pillar to post. So it is not just see, there's a very settled legal principle. Power corrupts, and absolute power corrupts absolutely. So Waqf Act 1995 gives absolute powers to Waqf board, and therefore it has been challenged, and we are working on it.
That sounds good. Thank you, Vishnuji, on that. It is painful. The next question is, it is so painful to know the struggle and the ordeal we had to go through to get Ram Lalla Virajman. Will the road for Sri Krishna and Kashi be any different?
No, it's a very good question, and I'll answer it. See, as I told you that the dispute of Jerusalem, it took 2000 years and no one is able to solve that dispute. We are very fortunate that we saw the judgment of Ram Janmabhoomi in 69 years, and this is what Justice Gogoi said, that it will be miraculous if we write a judgment and deliver a judgment within 1 month. Because if you remember, before 9th November 2019, before that judgment was reserved, and within 1 month the judgment was delivered in such a hotly contested case where the records are in 10,000 pages. 3 trucks had come from Allahabad High Court to Supreme Court with the original records. So it was that voluminous. So the point is that we have now, because of this, we can say information technology, and because of this latest developments in technology and the codes getting digitalized, there is so much of development and so much quick information which is passed that it took, just I'm giving you an example, that in Ram Mandir case, the suit was filed in 1950 before the Faizabad court, as I told you. And the case was transferred in 1989, seeing the national importance of this issue. So 39 years it took for a court to realize that this matter is of national importance. Let me tell you, sir, in Krishna Janmabhoomi case, we filed the civil suit in 2020. I moved an application just like Ram Mandir case in 2023 before the Allahabad High Court, to be precise, in the end of December of 2022. And Allahabad High Court on 26th of May 2023 realized the importance of Krishna Janmabhoomi and transferred the entire trial to itself for original trial. So what happened in Ram Mandir case for 39 years was done in Krishna Janmabhoomi case in 3 years. The ASI survey was ordered in Ram Mandir case in 2002, after 52 years. In Gyan Vyapi case, the ASI survey was ordered in 21st of July 2022 by the District Court of Varanasi. It was upheld by the Honorable, 21st of July 2023 by the District Judge of Varanasi. It was upheld by the Allahabad High Court on 3rd of August 2023 and upheld by the Supreme Court on 4th of August 2023. And today we have the ASI report filed in sealed cover before the Varanasi Civil Court. So what took 52 years in a Ram Janmabhoomi case to order a ASI survey, here we have moved so fast that ASI survey has been ordered, it has been conducted, and the report is filed. So I believe the answer to your question is that I believe that all these disputes and the judgment, we all have the benefit of the first legal principles which have been laid down by the Supreme Court in Ram Mandir case. So I believe that all these cases will be solved very quickly, and we are fully prepared from the Hindu side to lead evidence in all these cases. We just don't want any delay tactics. If any party is ready to argue their case and lead evidence before the Allahabad High Court or before District Court of Varanasi or Mathura, we are completely ready. From top to bottom, we can lead evidence in both the cases. So it's just if no one plays delay tactics and they're ready to come and argue in the court, I think very soon, and I feel and I believe that within 1 year, this case will be decided. Let me tell you, in Kashi case, the Allahabad High Court has already given a direction that this case must be decided within 6 months. In Mathura Krishna Janmabhoomi case also, the Supreme Court has said and orally observed that this matter should be decided at the earliest. So what this entire civilization is asking today is the dispute being resolved by the court at the earliest. So I believe it will be done very soon.
Yeah, it is heartening to see that there is an expedited timeline and requested by the courts, and we are all working towards it. So thank you. Moving on to the next question. Islamic invaders have destroyed religious structures in other countries too and repurposed it as a mosque. Is there any example of such structures being reclaimed in other countries, or is Ram Mandir the first one?
No, I think I can rephrase it like this, that there are various examples in various parts of the world where various other faiths, their mosque or churches have been demolished and it has been continuously converted by the other community into their own belief, faith and system. But Ram Mandir is the first example where a temple was demolished and the entire civilization had fought for this legal battle, and through court after 69 years, first time the temple has been reclaimed. And if you will note this entire struggle, in Places of Worship Act 1991, Ram Mandir has been given an exemption. And the exemption is that the lawsuit which has been filed to reclaim Ram Mandir will carry on in Section 5 of the Places of Worship Act. So this is the first of its own kind.
Thank you on that piece of information. So the other question is, how are we going to bring back, now everybody is interested, how are we going to bring back the rest of the 40,000 temples?
See, the very strong legal principle is, let me tell you, when I tell it on various news channels, they ask me, I am not going to give any concession or any compromise, not even an inch of land. People say that Kashi, Mathura दे दो, उसके बाद बाकी मंदिरों पे बात नहीं करेंगे. सॉरी सर, अगर काशी मथुरा इंपॉर्टेंट है तो हिंदुओं के लिए भोजशाला भी इंपॉर्टेंट है धार में, जहां पे माँ वाग देवी का, माँ सरस्वती का मंदिर था, जहां पे माँ सरस्वती की मूर्ति हटा दी गई और वहां पे हर फ्राइडे को नमाज पढ़ी जा रही है. जो यज्ञ कुंड है उसमें थूका जा रहा है, संस्कृत की ऋचाएं मिटाई जा रही हैं. हिंदुओं के लिए कुतुब मीनार का कुव्वतुल इस्लाम मस्जिद भी उतना इंपॉर्टेंट है, जहां पे लिखा हुआ है कि 27 जैन मंदिर और हिंदू मंदिर को तोड़ के उसके मलबे से कुव्वतुल इस्लाम मस्जिद बना दी गई. हिंदुओं के लिए टीले वाली मस्जिद लखनऊ की भी इंपॉर्टेंट है. हिंदुओं के लिए ताजमहल भी इंपॉर्टेंट है, और हजारों मंदिर जहां मंदिर तोड़ के. वी आर ओनली टॉकिंग अबाउट दोज टेम्पल्स which are existing, and after demolishing a temple, a mosque has been constructed. Because what is the Islamic law? That we cannot demolish someone else's temple and construct a mosque. And Shastric Hindu niyam is that once a temple, always a temple. So here the question is not of any compromise. It is not just a question of Kashi and Mathura. Wherever we will find evidence that a temple has been demolished and a mosque or a church has been created, or temples is ruins in for just for the sake of argument, I am saying we will restore each and every temple back, because temple is the sign of religious and cultural richness of this country. What happens when a temple is there? एक spiritual awakening होती है पूरी country की. It was a sign of all our cultural activities.
True.
Why the invaders demolished temple? For this very principle, that if you want to rule this entire civilization, it is best to demolish their temples.
Absolutely.
So that's why each and every temple we will restore through courts of law, through constitutional methods.
Absolutely, absolutely. And I'm combining 2-3 questions which has the same essence. They are asking, how can common Hindus contribute to the ongoing legal battles in Mathura or Kashi or other places, through financially or any other means? How can we support your efforts? That's the question.
Actually, I do not take any contribution from anyone. And I had said it very openly and boldly that this is a fight my father had fought Ram Mandir case from 1989 till 2019. And no one in the country can say that he has taken a single penny from anyone. Everything is spent from his own pocket. So we believe, and not because of that, we believe that it's our duty. It's not a fundraising exercise, sir. It's an exercise where we are talking before you so that you can be a part of this battle. I want this support from you, that those who can write, please write. Those who can speak, please speak. Those who can shout, please shout. And those who can't do anything, please stand with all these persons who are doing these things. It's not, if you cannot do these civilizational battles by funding an individual. If you will fund an individual, what will happen? You will fund me. If I am not that much good enough to do my travel tickets and all, then I shouldn't have taken this battle. So we are capable enough to fight the battle, and we need the community to stand.
Yeah.
We need this entire community and civilization to stand for this cause and say that अगर हमारी मंदिर को, मैं बहुत ही शालीनता से आपके सामने कहना चाहता हूं, हमारी मंदिर क्यों तोड़ी गई? Why did they demolish our temple? Because they knew that if you want to conquer this civilization, you have to destroy them culturally. You have to destroy them spiritually. And that's why temples were the spiritual centers of all the Sanatanis. And today, we need to get them restored. आज माँ वाग देवी, जो मैं भोजशाला का यहाँ पे आपके सामने उदाहरण दिया, जो राजा भोज ने वहां वाग देवी की स्थापना की थी, जो प्राण प्रतिष्ठा होती, मतलब क्या होता? मतलब देवता को हम बुला रहे हैं और देवता को माना जाता है कि वो उस मूर्ति में विराजमान होते। तो यही बात पीवी काणे ने अपने धर्मशास्त्र में कही है, यही बात गोपाल चंद्र शास्त्री ने और बीके मुखर्जी ने हिंदू लॉ में कही है कि मूर्ति तोड़ने से देवता का अस्तित्व खत्म नहीं होता है, देवता वहां पे इनविजिबल फॉर्म में विराजमान रहते हैं, अप्रत्यक्ष रूप में विराजमान रहते हैं। इसीलिए इन सारे मंदिरों के उद्धार की बात कर रहे हैं कि इन सारे मंदिरों में आज भी देवता अप्रत्यक्ष रूप में विराजमान है, उनको रेस्टोर करना है। उसको रेस्टोर करने से क्या होगा? स्पिरिचुअल अवेकनिंग होगी सारे लोगों की। और इस लड़ाई को फंडिंग की जरूरत नहीं है, इस लड़ाई को अवेकनिंग की जरूरत है।
Absolutely.
Absolutely, absolutely. And thank you so much for you, to you and your family for that unwavering support to the Sanatan Dharma. It is really, it is inspirational. You guys are role models to all of us, all of the Sanatanis across. Similar to this question, of course, yes, not financially support, but be strong on your own and, be the Dharma warrior yourself. But there was one question, how to prepare our next generation for the fight.
आई थिंक देखिए बड़ा अच्छा एक काम किया मिस्टर श्रीधर पोटराजू ने। मिस्टर श्रीधर पोटराजू एक लॉयर हैं, सुप्रीम कोर्ट में एडवोकेट ऑन रिकॉर्ड हैं और बहुत ही सीनियर मेंबर हैं बार के। राम मंदिर के केस का उन्होंने पूरा डॉक्यूमेंट, अगर किसी को राम मंदिर के केस का एक एक डॉक्यूमेंट चाहिए, आज वो वेबसाइट पे अवेलेबल है वाद प्रतिवाद के नाम से। यू जस्ट टाइप वाद प्रतिवाद, all the documents of Ram Mandir of the court records and apart from court records are available in Vad Prativad. So like this, I think all these documents which we are working on, we should get them digitalized. We should get them before in a website form. तो उससे क्या होगा, ये जो एक कम्युनिकेशन है, ये जो रिसर्च है, ये ट्रांसमिट होगी जनरेशंस आफ्टर जनरेशंस। हो सकता है हो सकता है मेरे फादर की लाइफ टाइम में ये हो, मेरी लाइफ टाइम में हो, पर जनरेशंस आफ्टर जनरेशंस ये जो रिसर्च है, ये जो डेटा है, ये ट्रैवल होता रहेगा। तो ये सिविलाइजेशनल बैटल है, ये कभी ना कभी तो इसको हमें जीतना है, और उसके लिए ये जो काम है डॉक्यूमेंटेशन का, ये एक बहुत इंपॉर्टेंट काम है, और उसका जीता जागता उदाहरण है वाद प्रतिवाद जो मिस्टर श्रीधर पोटराजू ने किया है। ऐसा काम हम लोग सबको लोगों को करना चाहिए।
Absolutely. Wonderful, wonderful suggestion, Vishnuji. Jayji, you had something to say? There are last two questions and then we can wind up.
Sure.
Or
I had quite a long list of questions, but many of them have already been asked and answered. So thank you for all that. Vishnuji, your passion for civilizational battle is obvious to everyone. Your father's, yours, and many of your colleagues. My question is, we are sitting remote here, 10,000 miles away from Bharat. We only see what we see on various news media and all that. But you live there. I'm wondering, is the next generation connecting with the civilizational loss that our society has endured over these 1,000-1,200 years? Are they starting to feel the ownership for recovering from those losses, or you think they're still kind of living in what we call la la land? Yeah.
See, there are two parts to this next generation. The many of the people whom I meet, and I am connected to the ground and grassroots, many people are connected to this civilizational battles, and they feel that yes, we should reclaim all the temples which were demolished in the past, and we should make our country a spiritual hub, a global spiritual hub. But many people who are into you can say like various other aspects of life which are not spiritual, they are not connected with this fight. So it's a mixed but I can still say very confidently the majority of the youth is with this fight, the majority of the youth. But obviously in such a large society there are various other where there are various sections of the society who do not believe in these battles. There are various sections of the society who say कि मंदिर मस्जिद की लड़ाई में क्या रखा है, वहां पे हॉस्पिटल बना दो, कॉलेज बना दो, मंदिर बनाने से क्या होगा। देर आर पीपल, बट जो मेजॉरिटी चंक है यूथ का, दे आर नाउ अवेकेंड बिकॉज ऑफ द स्ट्रगल ऑफ राम मंदिर, एंड नाउ द यूथ इन दिस कंट्री वांट्स ईच एंड एवरी टेम्पल restored. It's a very clear message. I travel to Indore, I travel to Jabalpur, I travel to Coimbatore, I travel to various parts of the country, and youth today is connected to this civilizational battle, and they want each and every temple to be restored.
That is actually very heartening to hear, because my generation is obviously passing through. It'll be gone. Your generation will go through its own battles, but unless the so-called youth of the country, youth of the society is awakened to this great loss that we have endured, the future of our civilization is not in good hands unless that happens. And I'm very heartening to hear that is actually happening. And yes, there are going to be always people who are not connected with this. They want to eat, live, and die. and that's all fine. It happens. But at least the vector is in the right direction. The direction is right. Okay, that's wonderful to hear. I have one other question. There are many, but I know that Ram Lalla was dragged through mud in the court in the court case. He was called to be a witness for himself. His existence was questioned, and and so on and so forth. It turned into a really very ugly kind of a scene in the court. I'm wondering if you can just spend a minute or so just talking about that part. Who were the actors involved, and how all that sort of settled down?
See, we had seen an affidavit which was filed by the Congress government before the Supreme Court, wherein the affidavit it was said that Lord Ram is kalpanik. It's a myth. Lord Ram did not exist. According to me, it was a blasphemy. I do not have the right today to question anyone else's belief. And if you will see the basic core of all the religions, it is on belief. The Christians believe that Jesus turned water into wine. The Muslims believe they have their own beliefs. I do not want to dwell into those because यहाँ पे नारे लग जाएंगे सर तन से जुदा के. But the point is that we have our own set of beliefs. And when we have our own set of beliefs, you said that no, prove your belief.
Sure.
So that's why this affidavit was filed by the Congress government saying that Lord Ram is kalpanik. Mr. Rajiv Dhawan, who argued for the Muslim side, he made a statement before the court that Ramayana is a kavya. It's kalpanik, it's a poetry. It has no relevance with the real thing. All the Hindus are Talibanis.
Sure.
And apart from that, the Naksha, the original map of which was there in Iskan Puran was torn before 5-judge bench of the Supreme Court.
Sure.
And there were various, the Supreme Court also asked during the course of hearing that whether there is any Vanshavali of Lord Ram. Many people came in the lawn of the Supreme Court to say that yes, there is descendants of Lord Ram. So the question is that you can ask various questions about us from Lord Ram. But if you want to know the existence of Lord Ram, kindly go and deny Ram Setu. कोई डिनाई करे राम सेतु की एग्जिस्टेंस को, कोई डिनाई करे आज भी वो जो पत्थर है जो तैर रहे हैं, कोई डिनाई करे क्यों श्रीलंका में आज भी हनुमान जी के पैर के चिन्ह हैं, कोई डिनाई करे चित्रकूट में कैसे आज भी जो चित्रकूट जाके दर्शन करेगा वहां पाएगा कि भगवान राम की एग्जिस्टेंस है, कोई डिनाई करे पंचगणी के वो जो एरिया है जहां पे भगवान राम की आज भी एग्जिस्टेंस है. तो आप हमारे बिलीफ को क्वेश्चन कर सकते हैं और हम ये सनातनी हैं जो हम अपने बिलीफ को जस्टिफाई करने के लिए लॉजिक देंगे, स्कंद पुराण बताएंगे, शास्त्र बताएंगे, नियम बताएंगे, कल्चरल आफ्टर कल्चर कैसे भगवान राम और उनकी जो शिक्षाएं हैं हमारी जनरेशंस में पास हुई हम बताएंगे. पर अगर यही क्वेश्चन मैं पूछना चाहता हूं सर विद ग्रेटेस्ट ऑफ रिस्पेक्ट, whether any government in the country has this authority to give such kind of affidavit for any other religion. Today we cannot question on Hazrat Bal. हजरत बल में जो बाल मिला वो किसका है और वो किसने विटनेस किया कि ये प्रॉफिट मोहम्मद साहब का है और वो मान लिया गया, इस पे कोई क्वेश्चन नहीं है और हम कर भी नहीं रहे. वी आर नॉट क्वेश्चनिंग, वी आर नॉट एंटरिंग इनटू एनी ब्लास्फेमस एक्ट, बट द पॉइंट इज दैट दे हैव द राइट टू क्वेश्चन आवर बिलीफ एंड दिस हैपेंड so far as Ram Mandir case is concerned. And actually sir, this was an ugly fight because they did not want us to argue with a very straight legal principle. क्योंकि केस बहुत सिंपल था कि क्या वहां पे मंदिर तोड़ के मस्जिद बनाया गया कि नहीं. ये इशू ही नहीं था कि भगवान राम यहाँ पैदा हुए कि नहीं. ये इशू जानबूझ के बनाया गया.
Absolutely.
To demean our faith. The issue was whether a pre-existing structure was demolished and Babri Mosque was created. It was a very simple issue. But you dwelled into various aspects of our belief faith to demean us, to degrade us. But ultimately, if anyone will read the judgment of the Supreme Court, the addenda, the Supreme Court has mentioned the judgment which has been authored by Honorable Mr. Justice Ashok Bhushan, that what is the belief, faith and astha of Hindus for Lord Ram. It has been documented by the Supreme Court.
Okay, wonderful. Thank you so much. One last question, and I don't know whether this is something that you can answer, but there is an established principle of war reparation. There are certain reparation for damage done in wars, war reparation policies. Even today, Greece is still asking for the reparation for the damage that's been done to that country during Second World War. So so I'm wondering if a concept like that could be brought in Bharat, where a war reparation act could be created, which basically says, look, all these properties that were damaged have to be repaired by those who occupy today, or pay
Yes,
damages.
we actually argued it. You have made a very nice point. We actually argued this international law before the Allahabad High Court,
Right,
that there is a treaty to which India is a signatory,
right,
where if anything has been done during war, it has to be restored. This international law was argued before
yeah.
the Allahabad High Court. But
Uh-huh.
more than international law and the treaties India is a signatory to, we have to first prepare ourselves for such kind of change. Because if you will see today, when we have enacted Citizenship Amendment Act, there is a huge debate.
I know.
When we are talking about Shabrimala, there is a huge debate. When we are talking about Gyan Vyapi, there is a huge debate. So forget about this kind of compensation. Today we are living in an era, and I'm sorry to say this, today we are living in an era where we are giving and compensating for the illegal possession they are having. Let me give you a very beautiful example, sir. In the land of Allahabad High Court was declared as Waqf property, a portion of land, and a mosque was there constructed. The Allahabad High Court had to come to the Supreme Court, and the Supreme Court said that this mosque which is existing in the Allahabad High Court is wrong, it is illegal. But since you have offered namaz from 1862, we will give you alternate land. So we are living in an era where forget about compensating the damages, we are compensating them for illegally offering the namaz. So there has to be a shift. There has to be a shift in the mindset, and then only the system will work. We are living in an era where people are saying कि काशी मथुरा के अलावा आप इसके बारे में और बात मत करिए. अब आप देश को मंदिर मस्जिद की इसमें मत झोंकिए. They are not able to. I just want to say this, sir. It's actually we are living in an era. ये जैसे आजादी के टाइम पे होता था ना, कुछ लोग कहते थे हमें डोमिनियन स्टेटस चाहिए, और कुछ कहते थे पूर्ण स्वराज चाहिए. तो जो पूर्ण स्वराज मांगते थे उनको कहा जाता था एक्सट्रीमिस्ट हैं ये, और जो डोमिनियन स्टेटस मांगते थे उनको कहा जाता था मॉडरेट हैं. तो आज हम उसी एरा में रह रहे हैं. जो लोग ये कह रहे हैं कि हमें सारे मंदिर चाहिए उनको कहा जा रहा है कम्युनल, और जो कह रहे हैं 2 या 3 मंदिर चाहिए उनको कहा जा रहा है हाँ ये जस्ट और लीगल बात कर रहे हैं. और अगर इस 3 मंदिर के लिए भी आप उसकी लड़ाई लड़ रहे हैं तो उनमें कुछ ऑल्टरनेट लैंड उनको दे दीजिए, वो अपनी मस्जिद कहीं और शिफ्ट कर ले. अगर कोई ये बात करेगा कहेंगे बहुत जस्ट बात कर, बहुत जायज बात कर.
Vishnuji, I think your passion for fighting for our civilization shows through very clearly, and I'm so pleased that you were able to share your thoughts with our audience. I'm mindful of the time; it's 10 minutes past the hour, so we're going to bring this session to a close. But once again, बहुत बहुत धन्यवाद आपका, and I look forward to similar conversations perhaps in future on related issues, and I certainly want to wish you the very best in the various fights that you're involved. Gyanvapi is obviously at the forefront, and then Mathura is right behind it. And I really, on behalf of all the entire Hindu community, wish you the very best in bringing them to a successful close. बहुत बहुत धन्यवाद. Namaskar.
Namaskar. Thank you. धन्यवाद.
Thank you.